Hey everybody, the Irish Demon here, back with another video. I don't know how in the name of Jesus I missed this yesterday, because I was literally watching Judge Corey J. Wiggins' court, and I didn't see this. I have absolutely no idea how I missed it. This guy goes absolutely nuts. I mean, naughtier than squirrel breakfast. I said breakfast instead of the other one because YouTube has changed their rules on profanity. So yeah, yeah. Anyway, so this guy is bizarre, and my assumption here off the rip is that it is likely drug-induced psychosis. That's just purely a guess based on my experience of dealing with people like this man here in the past. So take that for what it's worth. I really want to get your opinion down below, though. It'd be really interesting to see what people think about how somebody like this needs to be dealt with. I think the judge dealt with him excellently. Um, there was no kind of pussyfooting around, and there was no over harshness that I don't think would have been helpful in a scenario like this. I just think it was expertly handled, and yeah, tell me what you think. I need to try find the rest of it. I don't know if he actually did come back later, but if he did, rest assured, I will do my best to find it. I hope you're all having an absolutely great day. I hope you have a great weekend. Make sure and hit the like button. Leave an old comment down below, whatever it may be, because yeah, the old algorithm is not being very nice to me at the moment. So if you want to support the channel, hit that like button, leave a comment. I'd really, really appreciate it. And if you want to support the channel in other ways, of course, the usual ways are available. Super thanks, PayPal, any of that kind of crack. Really do appreciate everything, guys, and all of the lovely comments from since the last one. Just a quick update on that, by the way, and I promise I will get into the video then. All of the information about that person was sent to the necessary people. I was told I probably won't be updated in the near future unless they need whatever questions or whatever. So anyway, let's get stuck into this video. Let me know in the comment section down below what you think. It's yeah, I kind of feel bad for this guy, but at the same time, you know, gotta do what you gotta do. Let's play.
Person at the jail, what is your name?
You don't know my name?
Yes, what is your name?
You don't know my name. Who are you?
I'm Judge Wiggins. I'm the judge of the 84th District Court. I have a name on paper. I just want to confirm it's you. So who is your name?
You
What
asked
is your
me
name?
what is my name.
Yes, what is your name?
You're under investigation.
That's what, I'm sorry?
You're under investigation for saying what is my name. You don't know who I am since I've been here?
Are you Yuri Alexikov?
That is he.
That is you?
That is me, yeah. That is he, that's me. This is the name I was given.
Did were somebody from the defender's office able to meet with him today?
Briefly, he declined my help, but I would like to raise competency issues nonetheless.
I did not decline.
Sir,
I just asked for copy machines, I asked him to grab camera footages of body movements from these, see how to inspect body language, see if there's any kind of whispering while I was in that the jail cell talking, like for 24 hours straight. If they did not record my threats I was making during that stay at the jail cell, if they didn't record, he said, I'm going to check systems in other copy machines, if it's how it was been made and built in other jails, if it's capable of recording, and I'll see who manufactures these copy machines. If it's erased from that capability to not record, if it's been erased, you guys will all be charged for tampering with evidence.
all right. Well, I have a process I have to go through, so let me get through that first. So I have a complaint that alleges that on or about October 8th, 2025, in the village of Buckley in Wexford County, it is alleged that you committed the offense of police officer assault, resist, and obstruct. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and consecutive sentencing may be imposed if it happened in a place of confinement. Additionally, you've charged with...
Guys. investigation, my friend. Who you are, we're gonna put you under investigation, honorable. You're not an honorable judge anymore. Corey Wiggins, you're under investigation. Who you are, who we have contact with it. You're government employees, so you're within the terrorist organization. We're gonna find out because there's corruption involved. There was attempted assassination on me. I was poisoned. I have the right to defend myself. Any kind of Russia to be notified, any terroristic arrest. I said 7 months ago. You guys arrested terrorists. I said Russia has to be notified because I was poisoned. Any food given to me, I count America as there's terrorists. For corruption, you guys want to kill. So I want Russia to be notified, send a plane. You say, you already know they could just get the copy machines, get them and follow the orders. Follow the security I built inside me to combat terrorism and corruption. Thank you very much. And we will stand for the law. We will not bow down to filth and corruption in the system. We will not. We'll take action. We the people will take action. You're all, this county's under investigation for attacking, for accusing me, Judge. You're under investigation. You understand? For threatening October 7th.
Count number 2, you're charged with malicious destruction of fire or police property.
We're gonna monitor you. We're gonna see what you have because there was attempted assassination on me. All right? You better shut your mouth and sit. There's nobody.
That is a felony punishable by up to 4 years in prison and or a fine of
Listen,
$5,000.
I have the right to threaten. I was poisoned. I said a long time ago. Authorize a plane to land. I was poisoned. I have the right to defend myself to get out of this lane for terrorism. I have the right. Do you understand that, Judge?
Additionally, you've been charged as a 4th habitual offender.
Listen, I don't care about your charges. I'm gonna, Judge, if you insult me one more time, do it. Tell me you're gonna charge me. Contact Russia before you charge me. You're not allowed to charge me prior to any terrorist arrest. Russia to be notified. Did you notify Russia? You're under arrest.
That makes each of those charges punishable by up to 15 years in prison.
Sit. I don't care about your charges. Sit, you terrorist, corrupt terrorist. Sit.
On felony complaints, you have certain rights. You have the right to remain silent. All right, corrections, you can remove him. We'll try this at a different time. I don't want to endanger yourself.
Yes, Your Honor.
So yeah, there we have it. Like you can see where I was coming from there. Clearly, there's a problem here. The guy, I don't know if it's just regular old-fashioned psychosis or drug-induced. Either way, the guy's clearly got an issue. I think the judge just dealt with it really well. He was considerate of the man's safety, but also the corrections officer's safety as well, you know, because obviously the guy was getting more agitated. It wasn't going to get anywhere productive. So the obviously best thing to do in that scenario is to just stand it down and keep everybody safe. As much as I'm sure all would have loved to have probably heard this awesome gentleman out even more, it just wasn't going to achieve anything. So I think that was the perfect way to deal with this. But do let me know in the comment section what you think. In the meantime, I'm going to post this video now because I haven't been able to find him returning. Judge Wiggins is live right now. And there's nothing yet. So I'm going to keep an eye on that. If he does come back up, I will post it and let you guys know. I might not be on screen because I have to leave my mic and stuff here at the office. But I'll have my laptop with me. So I'll be able to post the video maybe with crappy headphone speakings, whatever. What's that called? Audio. And yeah, so I'll just let you guys know if and when I find it. And I'll post that. But yeah, I hope you guys enjoyed that one. If you did, make sure and give it a like and all of that good stuff. And we'll catch you in the next one. Sláinte. Okay, I take back what I literally just said. Like, literally, this is me 2 minutes after saying what I just said. So anyway, immediately after I began to upload the previous video, or the previous half of the video, so I've just deleted it to add it to this one. I just checked live right now, and yeah, this is the follow-up. Yeah, let's see what happens. I just know that it's about him, but I don't know what happens. I'm watching it live with you right now.
Yeah, he doesn't want to cooperate with that.
All right. Do you know, has there been any CMH involvement at all?
I really don't know, Your Honor. We just came back from our 2 days off, so I'd have to look in his file to check that for sure.
All right. Okay, thank you.
You're welcome.
We'll still go on the record with it. Court calls the people of the state of Michigan versus Yuri Alexakov. Case number 254333FY. The defendant does not join us today. We attempted to arraign him yesterday from the Wexford County Jail. It is clear that there was some sort of mental issue going on. I don't know if it's strictly mental or if there's some sort of controlled substance involved as well.
That's what I was
We
thinking too.
attempted to arraign yesterday. We weren't able to do that. We tried to do it again today, and he's uncooperative. I realize that there obviously hasn't been an attorney appointed yet. Ms. Lawrence, I believe that I can't continue to hold him indefinitely in the jail, so I'm going to have to set an interim bond. Do you have any comment regarding bond?
Yes, Your Honor. I was just reviewing the defendant's criminal history, and it is pretty lengthy. I know he has some stuff from Georgia, I believe, out of state, that include violent offenses and aggravated assault. In this case, he was being picked up on a warrant, which was for sending threatening messages to a judge in Manistee.
Wait a minute. Sorry, no. I thought that maybe that alarm sound was like either another video on my computer or something here in the background. I was like, do I gotta bunk out, or am I good to stay here and watch this? I'm just gonna have a wild guess here. Obviously, I don't know. Maybe we'll find out here in a minute. My guess is he probably went off, and because like just from my own experience of working in this exact environment, usually the holding cells for a court building or set up like this, where I worked, it was underground and they would come up in a lift, kind of like a dumb waiter. It was kind of weird, but usually it's like a holding cell pretty much just outside the back of the courtroom. So if he did go, oh wait, hold on, no, maybe not though. Didn't they say he was in Wexford County Jail? So maybe it's got nothing to do with that. But yeah, anyway, sorry about that. I just wanted to jump on this. So he's threatened judges before. Interesting. Let's continue.
That include violent offenses and aggravated assault. In this case, he was being picked up on a warrant, which was for sending threatening messages to a judge in Manistee, which I think clearly shows a public safety issue. He told officers, "You are going to die." He called them corrupt pigs, attempted to kick them, and once they got him in the vehicle, he eventually was kicking the windshield, which then cracked. Given the violent nature of not only this offense, but his criminal history, the people are going to ask for a $10,000 cash bond. Thank you.
Ms. O'Mara, I understand your office hasn't been able to communicate with him at all?
I've had some brief conversations. I would ask to make a statement, just.
Sure, yeah.
I would ask that the competency evaluation be done as quickly as possible. I don't think that he has the mental wherewithal to participate in his own defense or understand court proceedings at this moment. I would ask that CMH get involved as well. I would also ask that in his bond, perhaps there be, that's all I wanted to ask for. Thank you.
Just for anybody who doesn't know, CMH is community mental health. They do assessment and support. So I agree, like that's clearly needed here.
I don't believe I can order a competency evaluation because I haven't got him arraigned yet. You're asking for CMH involvement. Has your office done any type of reach out to CMH or any type of involuntary petition through the probate court?
Well, because we aren't appointed to the case, I didn't realize that was, I didn't think that was something I could accomplish.
Yeah. Right. I was just asking whether or not you had or not. Ms. Lawrence, are you aware of any attempt for involuntary treatment or?
Not to my knowledge.
Based on what's been presented today, even though I have not had the opportunity to officially arraign him yet, as I said, I believe I do need to give him an interim bond. But from what's been presented today, I do find that he is a threat to the community. Bond will be set at $100,000 cash surety. That's all I can do until I can get him in front of me to actually put conditions upon him.
I'm just dying for him to say when he's going to actually bring him back, because it's Friday now, so I don't know. Can they get him back in at the weekend? Maybe they might have an emergency sitting, or they might wait till Monday. I don't think he'd be much better tomorrow either way, but like, he's muted now anyway. So yeah, I think that's about the end of it, folks. I'm not surprised he didn't come back. It would have been cool if he did, but you know, obviously the guy needs help, right? He needs some kind of mental health help or drug help or whatever to get him before the judge here. I didn't realize he had such a history because it wasn't brought up before, but evidently the guy's got problems, and yeah, obviously this is the only path really. Like, you couldn't just cut this guy loose, not the way he's being anyway, with the threats and other violent behavior. So anyway, I'm gonna leave it there, guys. I'm absolutely exhausted, so I'm gonna pack up and go home. I think I might try. I'll see if there's anything else that I need to cover, because I want to stay on top of things, and if not, then I'm gonna head home. But thank you so much for joining me. Refer back to what I said when I thought this video was over about liking and commenting and all that, and we will definitely catch you in the next one. Sláinte.
Yes, it is. Good afternoon, Ms. Rice.
Afternoon.
Yes. Good afternoon.
Sorry.
You're all right.
Afternoon, Trish.
Good afternoon, Your Honor.
All right, let's start over again. This is file 24979LT. It's entitled U.S. Bank versus Patricia and Lawrence Rice. Ms. Rice, Lawrence was here early, the lawyer was here early, and I was willing to start early, but I forgot about you. So I said, well, let's wait for Patricia Rice to log in, and you're here now. This is a foreclosure action. There was a bank foreclosure on this property on Man Road some time ago. The property's been sold at a sheriff's sale. And attorney G. Douglas Tuma is here from the Trott and Trott Law Firm representing U.S. Bank. We were here on July 29th, and we learned that Lawrence is in the house and Patricia is not, and has not been for some time. There was a more than a year redemption period that's passed. The property was not redeemed, and at this point, the bank wishes to foreclose and take possession of the property. Is that correct, Mr. Tuma?
Yes, Your Honor, in large part. I think at the very end you misspoke. You said that we wish to foreclose and take possession of the property.
Yeah, it had
We wish
been
to object.
foreclosed.
Yeah,
Yes.
the foreclosure is completed. The 1-year redemption period is expired. There's been no circuit court challenge to the validity of the sheriff's deed. My understanding is Patricia Rice is out of the property and doesn't claim any interest in the property, but Mr. Rice is, and we are not aware of any of the very limited defenses that are available in a possession-only case post-foreclosure. We have not seen any raised in this case, so we would ask for a judgment of possession.
Mr. Rice, what would you like me to know?
Right here, June 10th, 2022 is when I filed for my disability. My first paycheck is December of 22. I have made every attempt with Select Portfolio Servicing that if you, and remind you, Mr. Middleton, I asked for a jury trial when I asked my case to be removed from the United States of America, because I'm not going to get a free trial with you oath takers moving in and out of my house. And Mr. Middleton, I will show you your paperwork that comes from Trout Law that says right at the top of it, Team J, Patricia Rice. Right at the top of my deed in abstract, my description of my legal property. And Mr. Middleton, Mrs. Patricia Rice started moving out in 2005. Mr. Middleton, the courtesy report sent to you on Discover and Capital One credit cards that explains that since 2005, she has moved in and out of my house and took at least $45,000 with her when she went, maxed my credit cards out. Mr. Middleton, you have all this. U.S. National Bank, U.S. Bank National Association has all this. Capital One, Discover, Pay Express. Every Pay Express card registered in that woman's name will show you the last time she left my home with about $14,000 cash, and I was maxed out in credit card debt and 25% interest. And paperwork coming from Trout Law says Team J. Mr. Middleton, from the time I left here at court last Friday, my poems, my presidential my presidential speeches that I've been writing, and the good Lord woke me up for 2 weeks straight and told me to push a pencil, not to mention 10 years of my poems like Dirt Cheap, and my lottery tickets. Every lottery office I bought a ticket from, I want to retailers' cameras, because Mr. Dirt Cheap and a lottery ticket was in Mr. Johnson's office with his security cameras. Everything is on security cameras that I've asked for, Mr. Middleton. And I asked for my case to be removed last week. So that means I want a jury trial. And that means I want it removed from the United States of America's U.S. Bank. It's just like Donald Trump, and cameras everywhere, and have me on recorded. And Donald Trump is involved with this. And I want Donald Trump's cases, along with mine, removed from the United States, because I'm not going to get a fair trial with oath takers, because we've already proven that here in St. Joe County with your phone. God bless, amen. So we can keep doing Trout Law and Team J with this St. Joe County and very nice oath takers that want to intimidate me when I stand here and speak my very right as a United States American citizen, that I want not only a jury trial, I want it removed from the United States of America, because I'm not going to get a free trial. And Donald Trump's, Joe Biden, and all the emails are coming with me. Then if not, every phone number I have that this county has blocked my emails and my texts, you're all under arrest. God bless, amen. Do I need my citizen's arrest handcuff, or does he have a shotgun pair? That's what I have to say, Mr. Middleton. But for the beginning, and for Team J, Mr. Middleton, Credit Union 401. I am going to speak my piece as an American citizen, as an oath taker right here behind me. That comes from his office, Trout Law. It may not be him, but it came from Trout Law. That Credit Union 401 in the United States of America, and I guess we better go with this. I want a jury trial. You have wellness checks and everything else called on me. Temporary insanity is what I plead. God bless. Amen. Temporary insanity, and you have it all on your security cameras and your wellness checks. And Robert Small, Jay Scott, Zach Kaminga across my street, invading my privacy like Mrs. Rice. And forgive her, because I love her with all my heart. There is a spot in there, but I'm worried about me now. Okay? And I am filing bankruptcy as of June 10th in the United States of America, because I do believe it's my right, because you guys, I waited 207 days and I did not disrespect the Social Security Administration's office, because they have 207 days. And if they have 207 days, U.S. National Bank Association has all my credit cards. They have all the proof. I should have 207 days. Every day that it takes for my disability to go through. And you're taking seniors and Americans home that are disabled and holding up Jill Scott and bipolar and Big Pharma. Big Pharma, bipolar medication keeps you bipolar. The cure is inside of you. It's reading, writing, and arithmetic. That's bipolar cure. Because bipolar kind of medication ain't doing nothing but keeping you bipolar. Read the symptoms, brother. Read the symptoms. And this ain't bipolar. No, you listen to me. This is my time. You gave me permission, and you are gonna listen.
I think we're in the manic stage of bipolar, but
you play manic stage, Mr. Middleton. This is anger. Because you know what it feels like when you can't keep people coming in and out of your house, and it's law enforcement? Do you? You did the search warrants. God bless, amen. You did, Mr. Middleton. This county. And just like the man, when I mentioned Dane Scott and he looked at you, same thing Officer Lackey did when I called him about the very turtle that they exterminated. It was probably an endangered species that you want to play your little games stood about this damn tall. And it was on Facebook and it was on Man Road because the car went by. I said, just a minute, let me go. This is weird. And I'm going to post it.
Just let him go. I'll give him till 2:30.
In bankruptcy, I want a jury trial. I am pleading temporary insanity, and I want to file bankruptcy. And it's my disability that I have to wait on the government has to wait on me. And children being molested in Constantine, Michigan public schools, and you all are going to tell me I got to wait till 2:30. Mr. Middleton, 401. Credit Union 401, United States of America. Instead of taking it, if they were smart, they'd empty their accounts or tell you, let us open up the credit union with $100 billion and take the taxes and the Social Security from it so the government gets their help they need. God bless, amen. It'd be for the American citizens. It'd be for me. It'd be for my disability. God bless, amen. And it's just the beginning. But I did ask for a jury trial when I said move my case out of the United States of America. That is my God-given right. And Donald Trump and all the cases and all the security cameras, I want you to think about it, Mr. Middleton. They're coming with us. God bless and amen. Because I need it for my trial.
All right, thank you.
You're welcome.
Ms. Rice, anything you wish to say?
I did not take any money from him, sir.
All right,
I
well, you
did
don't
not-
have any interest in this property.
Pay express cards, sir.
Is that true, Ms. Rice?
And all the fuel on the Capital One cards.
Just a minute.
Mr. Middleton, everything is proof on the Capital One cards. You have it.
Well,
And
that's
they
not
discover
much-
cases that you,
before the court.
your court system.
Mr. Tooma, I really wish I had a judgment here, but I don't.
Your Honor, we'll email one over quickly. I've got it in front of me. I just wasn't sure of this court's procedure for filing.
All
But
right, the email address is 3bcivil@stjosephcountymi.org.
Before you leave, sir,
So just a sec. Elaine, look for this judgment, and as soon as you get it, please bring it in the courtroom.
before you leave, sir, Mr. U.S. National Bank, are you there?
Your Honor, I just have to step to my scanner very
Are you there,
quickly.
Mr. U.S. National Bank? I would like for him to see this camera, right here. In the cage that you sat right here last week and agreed to, that I caught COVID in it, and there was no way to escape it for 9 days. And you sat right here in this courtroom last week and agreed there was no way for me to escape COVID. Do you want to show Mr. U.S. Bank this phone? Because I want him to see the cage I was in, that Mr. Warren Buffett decided to fire me instead of paying me for the COVID that I caught in his cage. Mr. Middleton,
No, I don't think he needs to see it. I accept if you were in a confined
because
space.
you sat right here in this courtroom and said there was no way for me to escape COVID in that cage.
Probably not, no. All right,
Probably not. No.
Mr. Rice, the cold hard truth is this has to do with a payment for property that you're living in.
And I would have had,
No.
if I would have got my half grant, would have caught it up in that cage, Mr. Middleton,
All right.
that you sat here and agreed to.
Yes, now stop.
And it's registered in this court.
I
God
gave-
bless, amen. Okay, I'll stop.
All right, I gave you.
But you will remove this eviction, this foreclosure, and this possession from this courtroom and the United States of America. And that is my given right as a jury trial. God bless, amen.
All right. I don't know where I'd remove it to, the outer limits. Anyway, you have 10 days to vacate this house or you're subject to being evicted. You also have 10 days to appeal it. 10 days from.
And forgive me, dear Lord, for I have sinned. Mr. Middleton, I am allowed legal help, and I have called legal aid every day this week but 3. God bless, amen. You keep sitting there doing this, Mr. Middleton, because I'm coming for you, brother. And hopefully I can find a real old taker.
Your Honor, I must have.
And I hope I live streamed, dear Lord. God bless, amen.
I must have written down the email address incorrectly because it bounced back. Could you give that-
3bcivil@stjosephcountymi.org.
Donald Trump and Vincent DiCarlo, Pandora's box in St. Joe County. God bless, amen.
All right, sir. If you wait outside, I'll make sure you get a copy.
No, I'll hear anything you have to say, because you're not gonna run your mouth after I walk out the courtroom.
Well, you have 10
You can be
days.
trusted about as far as I can pick you up and throw you. You're probably not that far.
Well, I'm heavier than I once was, but yes, you have 10 days to move or you're subject to being evicted.
You have right now to remove yourself from the courtroom. You corrupt official. God bless, amen.
All right, you're good to go. You wait out in the hall.
Pedophile. We're gonna find them all.
Sorry, I'd go through that, Your Honor.
Oh, it's part of the job. Miss Rice, I know you've been struggling with this for a while. There's no sense to stir the pot. It is what it is. He's in the property. It's been foreclosed on. The redemption period has passed. Miss Rice, my recommendation to you would be you contact Sergeant Bruce Morse at the Sheriff's Department in 10 days. When they go to execute this writ of eviction, it's going to be very unpleasant. I know you do have some things there that you claim belong to you.
Mustafan case that's scheduled for a jury readiness conference for today's date. Perhaps we'll start with Mr. Reynolds. Are we ready to proceed from the city attorney's office for the jury trial?
Yes, Your Honor. I will just note that our office filed a motion to add 2 charges to this case earlier today. We are moving the court to add the charge of threatening bodily injury and use of fighting words.
All right, let me pull up the motion.
And Judge, while the court is doing that, I did attempt to advise my client of those charges, and we weren't able to get through that. So I would ask the court to advise him of those additional charges.
I'm going to need to do that, obviously, then. Okay, so do you want to take a position with respect to the motion to amend?
Your Honor, I will let the court know that I was having a bit of trouble communicating with my client as we were talking earlier today. So I have some concerns.
Okay, why don't we have you raise those concerns for me then now, because I do want to be able to address the motion to amend.
Well, as I just expressed to the court, I was attempting to advise him of those charges that the city attorney would like to add, and I was not able to get through that conversation with him. I spoke to Mr. Reynolds. I do have some concerns about my ability to communicate with him and his ability to assist in his defense because we are having trouble communicating. I don't know if that's something that's temporary for today. Obviously, I haven't filed a competency motion because I kind of wanted to see how this hearing went. So I guess at the very least, I might ask for some additional time to talk with him about those added charges.
Okay, why don't you do that? I'm inclined to, because of the rules of procedure do allow for a motion to amend to be filed anytime prior to the trial date. Obviously, I would have to advise and take pleas on those additional charges, and that might impact whether we go forward with a jury trial on the existing date or not, because speedy trial could start anew on those 2 new charges, but we could have some discussion about that as well. So do you want to take a break right now?
I don't think that me speaking with him today is going to be helpful.
All right, so Mr. Mustafan, you've heard Ms. Talene talking about your case, that she's having some difficulty talking to you about your case. Do you want to respond to that?
Yes, that is a biased opinion. She asked me to go out to the room, which we did. Then she asked me to wait because she was texting someone else, whomever, I don't know, it's not my business. While I was waiting for her texting that person, I was carried away. I was looking at the wall, at the ceiling. I don't know, just keeping myself busy, not to get involved with her doing, so to say. After she was done with texting, she looked at me and she's like in elevated voice, she started talking to me. I explained that she doesn't have to raise her voice at me. And she said that I'm not paying attention. I'm looking at the wall. I'm looking at the ceiling. And I explained that while I was doing so, she let me know that she is busy texting or doing whatever business which is not affiliated to my case specifically. And this is the conversation she's bringing out from the room, saying that we couldn't have a conversation and she didn't have a chance to explain about additional charges which were added to my case. It doesn't make sense. Yes, you didn't have a chance to explain because you were busy first texting another client, as you mentioned it, and then you were busy raising your voice at me for no reason. I didn't even understand for what. I mean, what did I do wrong to you?
Okay.
Then she just walked away from the room, and that's all. It was done, basically. She came in, she sat here, and now you are having the conversation you are having. That is the case, basically.
All right, so a bit of a conflict today.
Conflict, I didn't even have a chance to express myself verbally in one way or another. As I mentioned previously, she was busy doing her thing. I mean, I cannot be like forcing myself upon someone if she's busy texting another client while she's in the room with me, and the concern should be like concentrated within my context.
Well, let's take a moment then. There doesn't seem to be anything that prohibits you from having a brief 5-minute conversation with her right now.
She's right that this conversation wouldn't go far.
Why not?
Because it was such a I mean, she walked away from the room like something happened.
Why can't you have a conversation with her now?
She didn't represent me.
Ms. Talene, are you willing to represent the defendant?
Yeah,
All right, so Mr. Mustafa?
You are being dishonest then?
I am not being dishonest. I did not say that.
But you created that impression when you walked out from the room without saying anything, that you're not willing to represent me.
Are you willing to have a conversation with her, Mr. Mustafa, about your case right now?
I don't think this is going to go any further. I mean, after this, what she said, it wouldn't register within my conscious mind. I wouldn't be able to take any type of conversation.
You're not going to have a conversation with her?
I'm sorry?
You're not going to have a conversation with her when she's willing to have a conversation with you about your case?
But we had a chance, though, and it didn't go far.
It is not the court's job to mediate conflicts that you might have with your lawyer.
I don't even comprehend the reason of the conflict.
Doesn't seem like there should be a conflict. You may not have liked the fact that she wasn't talking to you directly in that moment, but she's providing she's providing you the opportunity to have a conversation with her now about your case. And I don't see a good reason why you should not have that conversation. If you do not want to be represented by a lawyer, you can indicate that, but this is your lawyer. This is the lawyer that I've appointed in your case. If you want a lawyer to represent you, you're going to work with Ms. Talene.
But in this case, our relationship is forced by a court itself.
I'm not forcing a relationship. I'm giving you the opportunity to have counsel. And the court's going to pay for your counsel. That's right. But I'm not forcing that. If you want to have a lawyer represent you, it's Ms. Talene as your lawyer.
Okay, which is my other option?
To represent, you can represent yourself. You can represent yourself in the case if you choose to.
I will express myself verbally and I will say everything what I know, which is related to the case specifically. Ever since you've assigned a lawyer or, the defense to me, we haven't met. I mean, we haven't had any conversation over the phone, over the text message, email, any other type of conversation.
Okay.
So this is basically second time I had a chance to see her.
Right.
And which didn't go far. So she's.
But you're prohibiting it from going forward right now.
She's incompetent about the case. She doesn't know what is going on. We haven't had personal conversations ever. The last one a few minutes ago failed. So, I mean, I would have a good chance just to explain myself in the best way possible, that's all. It would be the best choice. Since she doesn't know, and I do, I mean, it related to me specifically.
Okay. All right, I've heard from the defendant. Ms. Talene, if you're suggesting that the defendant's position here constitutes an inability to assist in his own defense that would constitute a competency challenge, I don't have that in front of me. I have someone who perhaps doesn't want to interact with you in the way that you want to interact with them, but I don't view that as a competency issue from my perspective. I don't think it's been raised such that I could rule on it.
Well, and as I said, this sort of came up this afternoon, so this wasn't something I had been planning to be discussing.
Right, okay.
Yeah.
But we do have a problem because it appears to me that Mr. Mustafan is not willing to have a conversation with you about his case. Is that right, Mr. Mustafan? You do not want to have a conversation with Ms. Talene at this point?
Well, going back to my previous experience, which we had just had a few minutes ago, I'm recalling unpleasant experience, which is incompetent from her behalf. You know, she's not as, she doesn't behave as one could have expected, specifically within the judicial field. And yes, I'm willing to say things on my own behalf. Yes, I'm expressing myself verbally for my own case.
You're expressing yourself right now. The question that I have.
But the hearing, though, did it start yet, or we are still like?
We've called you.
It's at 2 and we are at least 40 minutes late. Over here, it says 2.
That's right.
Jury readiness conference.
That's right.
I don't know. I don't know how it works. In my opinion, if it says 2, it means 2 exactly. Over here, we are already.
Well, you're not correct in that. It's 2 o'clock for you to. It's
double check if we are in a conference or this is a pre-conference. What is this?
Let me explain that.
Thank you.
Right. You are scheduled to be here at 2 o'clock.
Okay.
All right. The court does its best to see cases in a timely manner. It doesn't mean that when someone's scheduled at 2, right at 2, the hearing's going to begin. Because at 2 o'clock, there may be conversations that the prosecutor wants to have with the defendant and the defense lawyer. The court may be engaged in another case at that time. So the case has begun. When I called your case forward, that's when this hearing began.
So about a little over 10 minutes ago?
That's perhaps correct.
Okay.
So the case that we begun the discussion about this jury readiness conference. The purpose of a jury readiness conference is determine whether the prosecution is ready to proceed with their case and whether the defendant is ready to proceed with their case for the jury trial that is scheduled on another date. And as part of that jury readiness conference, the prosecutor's responsibility is to, if they have legal issues that they want the court to address, they raise those legal issues with me. If the defense has legal issues that they want me to address, the defense can raise those legal issues with me. It's also the last opportunity for people, if they're going to have a plea bargain, a plea agreement that they reach, that they present that to the court. So all of that is part of this jury readiness conference. And so when Ms. Talene is meeting with you, and perhaps she's having conversations with the prosecutor, she's trying to get a handle on what's going to happen next, what your interests are, what the prosecutor's interests are, what legal issues are there. And so that's what the purpose of this is.
In order to resolve everything what you have just said above, we should be meeting more often and just because on the first hour meeting, I've explained that I do not use phone, I do not use texting, I do not use email, I do not use any other type of communication. The best for me is to come over to the courthouse itself for a meeting.
And you're here today.
Yes.
And I'm offering you the opportunity to have the meeting.
Go well.
But you can still have that meeting. You could still have it. We're running out of time because it's at some point Ms. Talene has another court appearance, but you could still have a 5 or 10 minute conversation with her right now. But it sounds like you're refusing to do that.
Nothing comes into my mind. I don't know what to say.
First rule on the motion to amend. I'm going to grant the motion to amend the add to 2 charges. And then I'm going to advise the defendant of those 2 charges. And then we're going to go from there. So the prosecutor has filed a motion to amend to add counts 2 and 3. 2 will be threatening bodily injury, which is a violation of section 534 of the Boulder Revised Code. And then count 3 would be use of fighting words in violation of section 536 of the Boulder Revised Code.
I would like to be specific. If someone came up with such a charges, I would like to know, what did I say to whom? And
hold on a moment.
When?
Hold on so I can step through this one thing at a time. All right. I don't want you to interrupt me while I'm advising you of the charges, and then I'm going to tell you what they are, and then we'll go from there. So I've told you what those 2 charges are. They both allegedly occurred on August 27th of 2024. Understand those 2 charges. I can read them to you if you'd like.
I wouldn't make such a claim. I am guessing what is happening over here, but no. And it's not related to my competence.
So they've alleged that you violated, the first charge was a trespassing charge. They've added 2 charges. I've granted their motions to amend. And now I'm telling you about those 2 charges. And as I mentioned, the count 2 that they've added.
Who did I threaten to do anything?
They haven't indicated that yet. They've simply indicated that the count 2 is now a charge of threatening bodily injury under section 534 of the Boulder Revised Code. I'm going to read that ordinance to you.
Okay.
The charge of use of fighting words is a violation of section.
To be specific within the context as well, if you came up with such a charges, I want to know the details.
I understand you want to know the details.
Yes, thank you.
That's not my job to tell you the details. All right.
What do you mean it's not?
My job is to tell you the charge. All right. And where it's my job is to tell you where it's alleged that this has occurred.
So you are judging me without knowing the details?
No. I'm telling you the charge. I'm not judging you. I'm not judging you, Mr. Mustafan. I'm telling you what the charge is. It's merely an allegation. It doesn't mean you committed the charge. I'm just telling you what the charge is. Now, at some point, it's an accusation. It's an accusation only. Use of fighting words says that no person shall, with the intent to harass, annoy, or alarm another person, repeatedly insult, taunt, or challenge another person in a manner likely to provoke a disorderly response.
The only people I had a conversation with that night specifically, it was police officers. That's all. I haven't had any other conversation with any other person.
Understood.
And everything what I've said, it was based on emotional state of mind. That is first. Second, I'm responsible for everything what I've said to a police officer ever in my life. And I'm responsible for what I'm doing.
Okay.
And
I'm going to remind you, I'm going to ask you again to let me finish telling you what the charge is and then asking you how you'd like to proceed with that charge. Okay.
This is not an actual court. This is a jury readiness conference. It means conference. I'm here to communicate about the case or on behalf of the case.
If you are not going to listen to me, we're going to have a great deal of trouble. All right. I do not want to be in a position where you continue to speak when I'm asking you to listen. I need you to listen so I can tell you.
You're threatening me then?
I'm not threatening anyone. I'm telling you.
You said a great deal of trouble.
We're going to have a trouble with getting through your case.
A great deal of trouble is expandable for you.
Mr. Mustafan.
Let's see how far it's going to go.
Mr. Mustafan. I do not want to have to do anything other than tell you what your charges are. That's all I'm trying to accomplish. But you're making it very difficult. You're making it difficult for us to get.
Conference mean is communication on behalf of the case, which is related to the context specific.
No, this is a time for the parties to confer with the court and let the court know whether or not they've reached a resolution and whether or not they're ready to proceed to trial. It is not a time for you to go talk about the details of the case. This is not that time, actually.
It's
No,
related to me. How do you mean?
it's not. I'm telling you what the rules
I have
are.
a right to ask about the details of the false accusation.
Not today, you do not.
Specifically,
Not today, you
which is
don't.
related to my case.
Not today.
Specifically. Not today, when? When I come back on the court day?
Yeah, on the jury trial date, you'll have the
So
opportunity.
then I'm gonna be able to express myself.
Yes, you are.
And talk on behalf of the case.
Yes, that's
But
right.
today, I'm just listening.
That's right. And being advised of what the new charges are. Okay?
What do I know? I know nothing.
So let me go over that charge with you. The charge is use of fighting words. I've described it. It says no person shall, with the intent to harass, annoy, or alarm another, repeatedly insult, taunt, or challenge another in a manner likely to provoke a disorderly response. That's the allegation that the prosecutor has made against you. They say that that's what occurred on this original date in Great Park.
No.
Do you understand the charge?
Over here, it's not Chautauqua, it's open space mountain parks. It's two separate properties.
Do you understand the charge?
City of Boulder, but it's not the same thing.
Do you understand the charge? Do you understand what he's
It's
alleged?
amazing the way you speak. If you have to be precise, specifically within the judicial field.
I think I'm being pretty precise.
I don't think so.
I read you the charge. Do you understand what the charge means?
So next.
Do you understand what it means? Do you understand what it means?
Okay, I got the point. Next.
No, but my question is, do you understand the charge?
Yes, but I do not plead guilty.
That's fine. That was going to be my next question. How do you plead to that charge, which is count 2 of use of fighting words? How do you plead?
I plead no guilty.
Okay, that's fine. The third charge and it's the second one that's been added is a charge of threatening bodily injury. And I'm not saying you're guilty. I'm simply saying this is the charge. It's an allegation. The allegation is that you threatened bodily injury in violation of section 534 of the Boulder Revised Code. You understand that charge of threatening bodily injury?
I plead no guilty.
Do you understand the charge? You're nodding your head. You don't understand it. Would you like me to read what the ordinance says?
Well, I'm assuming that it says I've threatened to kill someone, yes?
Let me tell you, it says no person.
Specifically a police officer?
Let me tell you what the ordinance says.
Okay, that's fine.
No person shall knowingly, by threat or physical action, place another in fear of imminent bodily injury. Do you understand that charge?
I do.
Okay, and how do you plead to that charge?
Not guilty.
All right, we're getting there. All right, so now I've accepted not guilty pleas. So there's 3 not guilty pleas that have been entered on the 3 charges that are pending.
And everything started with me trying to get water from the water fountain. And this is how far it has come. It's amazing. It is amazing. To me personally, yes. From someone who came from another country, yes.
All right, let's
I'm
talk.
stating it to your face. I have no respect to a police officer. And everything what I've said, I'm responsible for it. And that conversation, everything what he came up with is from within that conversation.
Okay,
Okay.
so let's get back to where we were talking, what we were talking about before. We're now in the position of you having pled not guilty to the 3 charges that are pending. Right now, the case is scheduled for a jury trial for November 14th.
Okay. At 8.
That's right.
Okay.
The question that I have is, right now, Ms. Talene is your lawyer. She's the one that will represent you at that trial.
I don't know how far it's gonna go. I'm not sure. Do I have another option?
Do you have another option of?
No, I'm asking if I have an other option.
Yes.
Or, I mean, can I get someone else? Because I don't think we will get along. Just the way she treats me. She doesn't have to raise her voice at me for no reason. I haven't done anything wrong. It's the same over here. I mean, first, she makes me wait while she's communicating with whomever, it's not my business. Second, when she's done texting, like suddenly she woke up and started yelling at me for no reason. Yo, I mean, would you please have a respect?
So if I'm understanding you correctly, you're suggesting that you have what the court calls irreparable differences between you and your lawyer, so such that she can no longer represent you. Is that what you're saying?
Or I wouldn't want her to represent me because that is my conscious choice.
You do have the right to choose between whether you are represented or not. In our court, you don't get to simply say, I don't like this lawyer, so I want you to appoint another lawyer.
But
it doesn't work that way.
Alone, though, I mean, she wouldn't even give me a chance to say anything. She just walks away from the room as soon as I ask her not to raise her voice at me. That's all I said, basically. Did I ask something like extraordinary? That I dislike when someone yells at me? Is it inappropriate within the judicial system of United States?
You have come to the conclusion that she's mistreated you. I understand that's how you feel.
Listening how she presented herself in our relationship at the very beginning, yes. This is my personal perception.
Right.
Thank you.
I, of course, wasn't part of that. I didn't see the interaction.
You are busy doing your thing. I mean, I don't have much to. I didn't expect you to be there. I'm explaining myself.
What I'm telling you is I can't simply say, oh, that must be the case, that Ms. Talene didn't listen to you and that she yelled at you and that justifies me putting someone else in the position of being your lawyer. You've said that. I can't conclude that.
I'm not defending myself. I'm just expressing my perception.
I understand.
Judge Khan, I'm just letting you know that the district court has asked me if it is at all possible to go upstairs because there's apparently several very lengthy sentencings.
And are you scheduled to be there at 3?
Yes.
See, her timing is precise. 3 is 3. My timing says 2, but it's gonna start at 2:30. It's not precise.
I mean, if I need to stay down here, that's what it is, what it is.
I think we need to reset the case.
Her time more than you care about my time?
We're going to reset this hearing.
Oh, okay. Got a point.
And then I'm going to look on calendars. I'll start with Ms. Talene and Mr. Reynolds. Are either of you available next Friday at 2:30?
Yes, Your Honor.
Give me one moment, please. Yes.
Okay, so we'll reset this for next Friday at 2:30.
Which is the date?
Friday, the 18th of October. And we're going to give you a written setting notice. You'll have something in writing from our clerk. We'll give you, Ms. Talene, an opportunity to file any motions that you think with respect to whether or not the court should allow your withdrawal or require your withdrawal. And Mr. Reynolds can respond to that. So if you can file that early next week, and we'll give Mr. Reynolds a couple of days to respond, just so I have something in writing to address the legal issues that are before us.
Yeah, and I think I could probably get something filed by Tuesday. Monday, I'm dealing with some bad stuff.
Let's just make Tuesday at 4 p.m.
Okay.
the deadline for you, and then we'll give Mr. Reynolds Thursday at 4 p.m. to be your response, if any. Mr. Reynolds to that. And then I can address that issue next Friday. I need some time to think about this. There's obviously a disconnect between you and Ms. Talene, and
No, there is a disconnect between me and the judicial system, the whole thing.
That may be true as well. I get you.
Thank you.
But we have to figure out a way to get you through your trial and have you fairly represented. And I don't know whether that means having you proceed on your own or whether it means.
To me, I have to be honest.
And Judge, I am
Just going
sorry,
back
can
to
I?
everything what I've been through here, and just to this specific case that I was trying to get water from the water fountain, which is outside, and how far this has come. That is mind blowing, man. It's amazing to me. It means that you do not make me a better person. That's all I got.
Okay.
And there is a price. A hefty amount. Someone would have to pay. As you make me pay, I will make you pay. You don't even look at me because
I'm listening. I'm listening. I'm not afraid. I'm just writing.
And Judge, since I have the date, would it be possible for me to run upstairs? Since I have the next
Yes,
date,
you can leave.
deadlines.
Yeah, at this point, we're just resetting it for the hearing. We've got the dates.
Okay, thank you.
Are we done? This is it?
I want you to hold on just a moment. Are you gonna print out?
I printed it, give it to him, yes.
And he's already got his signature on it?
A quick signature right there for me, just indicating you know that you're gonna be here.
I will be here.
Okay. All right, Mr. Mustafa, you're free to go. We'll see you next week.
Hey guys, I just got back from a nice long spin on the Harley, and then I was catching up with some courts and I came across this absolute beauty. Divorces and all that kind of stuff. It's nasty business as it is, but even nastier when you got a guy like this involved. Basically, he took everything and ran away to Costa Rica or Costa Rica, one or the other. I always get confused between those two. Anyway, so he complains and complains to the judge about this whole thing being put off so much, and the judge kindly reminds him that it is 100% his fault. And then on top of that, he makes some outrageous claims about his wife and the judge. Stay tuned towards the end for that. Anyway, folks, I'll catch up with you as soon as this is over, and we'll have a little chat.
And I need you to unmute, please. Mr. Backus, are you able to hear me?
Yes, sir.
Okay. All right, we're on the record in Nevin versus Backus. This is case number 2213862. The record should reflect that both parties are present by Zoom. We have Ms. Bostic here on behalf of Ms. Nevin, and we're set for a status conference today, as well as Ms. Bostic. You filed a motion regarding several different types of reliefs. You're looking for some damages related to the home in this case, attorney fees, some injunctive relief, and ultimately entry of the judgment of divorce. Is that correct?
That's all correct, sir.
Okay. Is there anything that you wanted to state in terms of argument? I mean, I went through your motion. I see that you've supplied all the documentation and so forth with that motion. Was there any argument you wanted to present today?
Not too far beyond that, other than, of course, to stand on the motion. These are the damages we calculated, and there's, I would leave it to the court's discretion to determine how exactly it would like to calculate those damages. We obviously have a very significant loss of equity between the two appraisals, as well as, and part of that loss of equity is the specific damage to the items that Ms. Nevin was able to identify, replace, or have quotes on. We're also, of course, standing on the request for attorney fees, given the work that was necessary following the damage to the home to get that sorted out. That should never have happened. It was in violation of the mediation agreement. And because the mediation was ordered, there are expectations that a party may be entitled to attorney fees if another party acts out or acts in a way that's contrary to a court order, and as well as to the extent that this is sanctionable conduct, the damage to the home after he knew it had been awarded to the plaintiff and after there was an agreement that he would leave it intact with certain fixtures present. We are asking for the injunctive period so that we have an opportunity for the judgment of divorce to go into effect. Before this court, there has already been, I know this court at our last hearing raised some concerns regarding the defendant's credibility and his good faith in participating in this divorce proceeding and making funds available. He's previously told the court that he is completely destitute and living in Costa Rica with no money and no or very little income, but the court determined and was very satisfied last time we met that he did in fact receive a very significant payment of money in a liquid form, that if he is now destitute, there should be some questions about where that went. So there should be some assets somewhere, and we would ask the court to further enjoin any movement of those accounts, just so that we have time to execute the judgment because of the amount of damages that we're asking for due to Mr. Backus' conduct before he left the home. And that's all.
All right, okay, thank you. Mr. Backus, what's your position on this?
Well, that's first I've really heard of this motion. I never received anything about the motion, so I don't have much to say about it. Really, I mean, she can try to get what she wants to out of me. I mean, that's fine. You know, I just want to proceed and get this divorce over with. As far as assets go ahead and search. So it's, unless you want to come to Costa Rica.
All right, Ms. Backus or Ms. Bostic, it looks like you served Mr. Backus with this by his email address that he provided. Is that correct?
That is correct. Pursuant to his statement on the record, I think last December, that he preferred electronic service.
Okay, so Mr. Backus, you might want to check your email. That's how you asked to receive documents.
Yes, sir. I check my email every day, and you know what? She never sent that. She never sent it. So I never received it. She never sent it. I've received every single email from the clerk of the court. She hasn't sent nothing, Your Honor. She could sit there and say she did, but she didn't.
I'll file my outgoing email with the court as well if that's necessary.
Yeah, absolutely. Yes.
Okay. All right. So Ms. Bostic, first of all, after reviewing the file and your motion, I do think that the injunctive relief that you're requesting is appropriate to prevent the dissipation of any further assets while this is pending. I think given that Mr. Backus has located himself outside of the country, given what's gone on at the home when he vacated it, and the condition that it was in, and there's been some exhibits filed to show that condition. I think in terms of the court's equitable powers here, I think in all fairness, that injunctive relief is appropriate and necessary to prevent either side from dissipating any assets until the court can make some rulings and some findings. So if you'll submit an order regarding the injunctive relief under the 7-day rule, the court will assign that. With regard to the damages and attorney fees, certainly that you provided all the documentation for that, but I think the court needs to have an evidentiary hearing and to take some testimony as to how those amounts were obtained and so forth. And Mr. Backus has the right to, a contested hearing to question those amounts as well. So I think if Ms. Bostic, if the court were to set this for, maybe a 2-hour or half a day hearing, would that be enough time for you to present the testimony you need on those exhibits that you submitted with your motion?
Yes.
Okay, so the court will set this for, I'm going to set it for a half a day hearing just in case at the court's next available date. Mr. Backus, you'll be provided with notice of the date and time of that hearing. To the extent that you want to contest the damages that they're seeking, then you'll need to be prepared to present your side of the case or any evidence that you'd like to bring before the court to contest the amounts that they're requesting, okay?
Yes, sir.
Ms. Bostic, is there anything else that we can address for your side for today's purposes?
Depending on what the court's calendar is, if the half-day hearing would be anticipated to be within the next 5 days, we could put on the proofs.
I'm sorry, you were breaking up a little bit there. Can you say that again?
Yes, depending on what the court's calendar is, and if we would have that half-day hearing within 45 days, we are prepared to put on the proofs today. Unless you would prefer that at the evidentiary hearing.
I'm not sure sitting here what my calendar's like, so I'd rather put the proofs on at the time of that hearing. We can certainly do that then.
Very good.
Okay. All right, Mr. Backus, do you have any questions at all?
Yeah, is my divorce final today then? Is that part of it done with? Huh?
No.
Pardon? It's not going to be done until we do this next hearing?
No, because I have to make some determinations about if and what damages Ms. Nevin might be entitled to, as well as the request for attorney fees. So all of that would need to be determined before we can enter a final judgment.
Lads and lassies, just a quick break in the middle here, just to let you know, a few of the most recent videos I've put up have been demonetized, so I'd really appreciate it if you go watch those, hit the thumbs up, share it, all that stuff. And if you want to help the channel in other ways, you consider becoming a channel member, a Patreon, or dropping a tip in the PayPal tip jar down below. Thank you.
Okay, one last question. How long does that usually take from this point on? I'm trying to get on with my life. I got a new baby here. You know, I'm going through the, U.S. Embassy for dual citizenship for her. And, this is a major roadblock for me. So, and this has been dragging on and on and on. It should have been done months ago, but here we are. And now we're going to postpone it again. I don't understand. I really don't. And I feel like at this point, would I be in contempt of court if I do not do any more and just let them do a divorce decree on me?
So to address your first point, number one, you're the one who chose to move to Costa Rica. That's resulting in a lot of the delays here. Number two, you're the one who chose to leave that house in the condition that you left it in, and that's causing the delays here. And number three, in terms of your question about what would happen, I can't really tell you that. That's up to you. You'll have to decide how you want to go forward. But from my seat, the delays here are all caused by you, so I don't think you really have any cause to complain at this point.
Okay, I strongly disagree with you, respectfully disagree with you. For one, I didn't leave the house in that condition. And that's why the sheriff's department, you said I did. The sheriff's department never prosecuted me. How come there wasn't criminal charges like Miss Bostic said there would be? Remember, she's in her motion, she said that. Okay,
I'm not going to debate with you. We have differing opinions, and that's fine. That's fair, but I'm not going to debate with you. We're going to proceed as I've indicated, and that's how we'll go forward.
Okay. One last question for you. Is there a way for me to appeal your decision?
Again, that would call for me to give you legal advice, and I can't do that. So you'll have to figure that out on your own.
Yeah, of course not, but you will for her. I think she's paying you off or something, but that's all right.
Okay, well, you can pursue that as well if you want. There's ways for you to make those grievances if you want to do that.
Oh, isn't that legal advice?
I'm not giving anybody legal advice.
You just did.
I don't think I did.
It's okay. You won't see me. You won't see me.
I'm not going to debate. I'm not going to debate with you, Mr. Backus. That's all for today.
Yeah,
you can go ahead.
Yeah.
Thank you.
See y'all in Costa Rica. Pura vida, as we say here.
So there we have it, lads and lassies. This guy, I don't know, it seemed like maybe he was on something. Let me know what you think down below. I'm not really sure. Just your kind of typical divorce, except multiplied by 100, it seems. Running off to a different country with all the money. Talking about his new girlfriend. And then claiming that the judge is taking money from his ex-wife. Standard stuff. Now, I know, to be fair, sometimes divorces can get really, really nasty and one side's just as bad as the other. But just on the face of it, it seems like one side in particular is way worse than the other. Anyway, folks, thank you again for joining me. I hope you enjoyed the video. Make sure and hit that like button and we'll catch you in the next one. Sláinte.
Yep, Your Honor, because of your stupid ass state of Kansas.
Okay, you've just been found in contempt of court. Appear. We need a bench warrant for his failure to appear today for failing to come to court.
Hey everybody, the Irish Demon here, back with another video. We got this guy over here, old Danny Boy, and he decides to do arguably the worst possible thing that you can do in court, and that is to swear at the judge. Not only that, but he also rage quits and gets himself a bench warrant. Now, I'm not going to do a whole lot of talking in this one. I just want you to sit back, relax, maybe get yourself a cup of coffee, specifically in an Irish Demon coffee mug, which you can find linked down below. Shameful plug. And as I said before, there's a good chance that this video will be demonetized, but we'll catch up about that here in a little bit.
Daniel Lyman, are you here?
Yes, Your Honor.
You still don't have counsel, is that correct?
Yes, Your Honor.
Well, let's take up your case.
I know today is my possession of marijuana on the payer appear and
Okay,
everything.
well, let me call that case number. We're on the record now in 2021 CR 274, State of Kansas versus Daniel Lynn Lyman Jr. The state appearing by and through Jared Regier, and the defendant in person and pro se. We have had a situation where you are supposed to pay November 28th of 2022. You did indicate you wanted to represent yourself without counsel and waived counsel on record. And you had been on diversion. You got another charge of driving while suspended. You ended up, it looks like, getting your diversion revoked, being found guilty at trial, sentenced, and you were supposed to have your case paid by today, February 6th. Now, what were you saying, sir?
The reason why I haven't had it paid yet is because the job that I was supposed to go for at American Eagle in Ottawa, it didn't plan out as planned. So I'm working at a motel over here in El Dorado.
Okay.
And it's just not bringing in as much money as it should. And I get paid twice a month. I have a lot of bills to pay, plus my court fines. I'm not trying to miss any of my court fines. I'm not trying to do any of that. I'm trying to pay everything that I can at once. I was just going to ask you if I can start paying maybe between $20 and $50 a month. And my first payment I can put on this one is on the 8th of this month, guaranteed.
Well, you've always been allowed to make payments as long as you had it paid in full by your pay or appear date, i.e. today. So, now remind me, are you married or single?
I am single.
And remind me if you have children you support.
Right now I have a stepchild that I support.
Now you're single, but you have a stepchild that you support.
Yes, because I am in a relationship. I'm not married or anything. I'm in a relationship, but I support me, my fiance, and our child right now.
Well,
Because
I don't know why you're supporting these, but why you've taken on new obligations when you haven't taken care of your old ones, such as paying your case. You owe, sir, $658.
Yes, ma'am, I understand.
And you have not made any payments since November?
No, ma'am. I've barely been working. Like I said, I have this job and everything. I've been paying my bills and everything because I do have rent to pay. I have my phone bill. I have my SR22 insurance that I'm trying to pay, so that way I can also get my license back. I have my fines to pay. I have a lot of stuff to pay right now, honestly, and I'm just not trying to go to jail over all this.
Well, I was going to say, I was going to ask you if you thought it'd be easier just to go serve the 90 days in jail and send these costs to civil collections. Do you want to do that?
I don't, because it just messed everything up. Or because I still have my Lyon County court case for my 2021 case back then when I had that case that I'm still trying to pay on as well.
What do you have going on in Lyon County?
I got it before this possession of marijuana case. It was a duty of driver / no DL at the time. And the They dropped the duty of driver down to a no DL, and I'm just having to pay on that of $377 as well.
So you had a car wreck
Yes, ma'am.
without insurance?
No, it was with insurance. It was with insurance.
Okay, and you didn't report it to law enforcement and they found out about it?
Yes, ma'am. It was my fault. I
Okay,
take
and
all
when
blame for
when
that.
did you do that?
That was in 2021,
Well,
almost 2 years ago.
this case was in 2021, June of 2021. When was your
And
Lyon County?
it was after I got served papers when I was on house arrest in Lyon County. Because I had completed my house arrest and I was on house arrest when I got into the wreck. I didn't report it. I got in trouble. I got a ticket.
How were you
And
on house arrest and driving at the same time? House arrest means jail.
house arrest, I was going to work and back, and I ended up getting in a wreck.
Okay,
And
so they gave you work release from your house arrest,
yes, ma'am.
and on your way to or from, you had a wreck, and then you didn't
Yes,
report it.
and I failed to report it.
Well, okay, well, I just kind of wanted an idea of what was going on over there. Have you paid anything on that case?
I've been slowly paying on it and everything. I try to make $10 payments. If I can't make it, I call them and let them know, and they told me just to pay it next month and everything. So I have owed $377. I've only paid $20 on their case so far too.
Well, how come they've gotten $20 and I haven't gotten anything?
I apologize. Like I said, I'm trying to pay everything all at once, and it's just all adding up on me. And I really don't want to go to jail over all this. I want to try to get it all paid. I know I'm not being very good at it right now, but I do apologize with everything I have, and
Okay,
my first
hang
payment I
on,
can make.
hang on, and you were on house arrest and you got served with papers for possessing marijuana in another county.
Ah, yes. He got arrested for possessing marijuanas. Can you imagine going into a dispensary? Can I get 3 marijuanas, please? Well, it's your lucky day, sir, because it's buy 3 marijuanas, get 1 extra marijuana free.
Is that what you told me?
Yes, because originally, back in 21, if you can let me just start over real quick, I got pulled over in the state of Kansas and in Butler County area, and I had my warrants active for Lyon County and Butler County at the time. I ended up serving my 7 days in Butler County for the city court. They transferred me over to Butler County or Lyon County after I got stopped for my possession of marijuana. And that's how I got my possession of marijuana. They did not take me to jail over my possession of marijuana. They charged me for my warrants, took me to jail over them. I served my time in Butler and Lyon County jail, got out on house arrest. By the time I got out on house arrest, I was served my marijuana papers. I got diversion for those. I completed my house arrest, got off, and now I just been fighting my duty of driver / no driver's license over there. Been trying to pay that off. Then I got another one through you guys for the no driver's license back in July and everything. And I just been trying to pay all 3 of these tickets off and paying my rent, my phone bill, my SR22 insurance to get my license back. I'm trying it all, and got a ticket. And I just feel like this is unfair on me. Just because I can't pay a fine.
Okay, sir, I understood you to say you drove in Lyon County, and you wrecked and didn't report it. So there, you drove that day, right?
Yes, and that was my fault. But in
And
the
then I
meantime,
understood that you drove in Butler County and after this case.
Yes, ma'am.
Marijuana case.
All
So
these
1
driving-
+ 1 = 2, Mr. Lyon. So you've driven at least twice illegally in Kansas.
Yes, ma'am, I have, but that is because I have to go to work and back. How am I supposed to go to work and back while I'm trying to get my license without anyone offering me to give rides? I'm not trying to walk out of town. If I live in Leon, Kansas with my parents at the time, how am I supposed to get back and forth to work if they can't give me rides? And I'm the only one with the vehicle, but they don't want to wake up to give me rides. And I have to go to work to go pay my stuff. How is this all fair with me? Because people won't give me rides. I can't drive and stuff like that. Yes, I live in El Dorado now and I walk to my workplace.
It's called being an adult, bro. Maybe if you didn't get into so much trouble with your driving, you'd be able to get back on the road legally and you wouldn't have this problem. I get it, it's not easy, but nobody cares. Work harder.
And everything. But
Where do you work in El Dorado now?
I work at motels, the Motel
Okay,
6,
you told me that. And where do you live?
Silverwood Apartments.
Okay, so that's not too far from where you work.
No, ma'am. And that's why I said I walk now. I don't drive. I'm trying everything that I can. You know, right now I feel like everything is gathering up on me and I can't have a chance to do anything because I'm trying to get my life together. I promise you, I'm not trying to drive. I'm not trying to get in trouble.
Stop. Okay, you said you haven't been given a break. It looks like you were put on the deferred docket disposition docket, which means you were what, given diversion in this case initially?
Yes, ma'am.
And then you didn't comply with it. That was a break. If you'd done what you were supposed to, the charges would have been dismissed and kept off your record. So wasn't that a break? And you didn't comply with it, so you got that revoked. And then you were sentenced and given terms. I let you pick when you were going to pay this off, and you picked today. And then you didn't comply with that. You know, I didn't have to give you probation when I sentenced you. Probation is a privilege. It's not a right. So that was a break. I didn't put you in jail, right? That's two breaks right here in this case.
Yes,
So,
Your Honor, you are correct.
and if I transfer you to reporting probation, that's still a break, and that's a third break. So I really don't think you have any grounds to sit here and say, poor me, Kansas is too mean to me.
Yeah, it is. It really is. If I had a choice, I would move out of Kansas right now and I would never
How can
come.
you say it's mean to you when we're giving you all these breaks and you won't quit violating the law?
I've been trying to stay out of trouble. I got in trouble once this year for driving, and I was trying to drive home from work.
For this year, you've already gotten in trouble in 2023?
Or not this year, 2022 is what I'm talking about.
Oh, poor you. So you keep getting into trouble, but it's absolutely everybody else's fault. So now when the chickens come home to roost, you won't take any accountability. Guess you better rage quit.
Sorry, I forgot it's 2023 now. But yes, in 2022, I only got in trouble once. I had not been in trouble ever since all my old cases. I only got in trouble that once in 2022 for driving back in July. I have not been in trouble.
We're not going to keep talking in circles here, and you're not going to convince
just
me.
move out of state because I'm done. I'm done dealing with this. I'm moving out of state. I'm moving right now.
Yeah, this isn't that home with your mom where you're like, I'm done with this, I'm moving. No, you're not going anywhere. In fact, no, you're definitely not going anywhere because you're about to get yourself a bench warrant, aren't you?
Well, no, not unless you have court authority in all your cases to move out. You're not, if you're on probation.
You guys ain't coming to get me. I will move out of state.
I am transferring you to supervised probation, and you have 30 days to get this all paid. Call your probation officer this morning.
I'm not doing any of it. I'm moving out of state. I'm packing my stuff up right now.
You're telling me you're not going to comply with my orders?
Fine. Yes, I will. I will apply with your orders.
Oh, I am going to, where do you live?
Silverwood Apartments.
Silverwood Apartments in El Dorado. I am transferring your probation. You are to call the probation office. And you have 30 days to have this paid in full.
Or else I go to jail.
You either go to jail or you get your probation extended, whichever we decide to do. If you can show me you need more time to pay it, that you've made a good faith effort, I will certainly consider extending it, but you will be in violation of your probation and it'll either be extended or you'll get it revoked and go to jail, one or the other. Because
this is really, really stupid.
Because you have, as I understand it, Mr. Regier, he has violated the law since he was put on this probation in November. And if that is correct, that's a violation of his probation. I understood him to say he got a driving while suspended. Is that right, Mr. Lyman?
Yes, Your Honor. Because of your stupid ass motherfucking state of Kansas.
Okay, you've just been found in contempt of court.
You know, I can do fucking less. Fuck you. I'm moving out of state.
All right, you are in contempt of court. You have now failed to appear. We need a bench warrant for his failure to appear today for failing to come to court. He's in contempt for his language, and we will deal with that at the next hearing, but please do a bench warrant as soon as possible, Mr. Regier, for his failure to come to leave court.
So there we have it, folks. We have this man-child over here who can't take any accountability for his own actions. It's everybody else's fault but his own. You heard him yourself complaining about the fact that he can't get himself out of trouble. So what does he do? Drop an F-bomb at the judge, get himself in even more trouble, and state that he's going to move out of state so that he doesn't face any of these issues. Me thinks that maybe everything's going to be revoked and you'll probably get your 90 days in jail. Well done. And then you also have that contempt charge on top of it. Well done. Anyway, folks, just to let you know, a lot of these kind of videos are getting demonetized at the moment because of some of the subject matter. So if you want to help this channel, make sure and hit that like button, comment and subscribe and all that stuff. Consider becoming a member or a Patreon or dropping a tip in the PayPal tip jar down below. Now, I'm giving away a box of Irish Demon merch and a few other bits from here in Ireland to one lucky winner every single month. And the way you can enter into that is for anybody who decides to make a donation through PayPal, every dollar would count as one entry. Also, the super thanks down below, the same rules apply. And if you don't have anything to contribute financially at the moment, then what I would ask you to do is leave a comment down below and let me know that you have shared this video. And if you do that, you'll also be in with a chance to win one of those boxes. Anyway, thank you so much, folks. I hope you enjoyed the video. We'll catch you in the next one. It's launch out.